So I think now we are live on YouTube and it is a good time to go and start the discussion. Okay, so I am putting my video on off mode. I think there are some signals issue. Okay, guys. So very good afternoon to all of you once again, and welcome to today's discussion on secondment of employees and related tax issues. So recently, we know, the Supreme Court has given judgment in the matter of service tax, wherein the Supreme Court observed that in the case of the secondment, it would be treated as service. And once again, the issues related to secondment of employees are now taking center stage in multinational companies. And also earlier, we know there was a judgment from Apex Court in the matter of Morgan Stanley. So in this presentation, what I have done, we would be briefly try to understand what is secondment, what are the models of secondment, what are the issues around secondment, and what court has to say on the secondment of employees. And if, let's say, depending upon how we classify secondment, if tax issues will come, what kind of tax issues can come. So what is secondment? Secondment, I went to Google and based on the dictionary meaning of secondment, it is the detachment of a person, such as a military officer, from his or her regular organization for temporary assignment elsewhere. The another dictionary talks about, gives the meaning of secondment as a period of time when an employee is sent to work somewhere else to increase the number of workers, to replace other workers, or to exchange experience or skill. So basically, going by these two meaning or definitions of secondment, it seems, and we all would agree, secondment is something temporary, maybe for a 1 year, maybe for 2 years, maybe for 3 years. So, one of the resources or one of the employee of a formal company or of a, original company goes to another organization or to another company for some short period, maybe 1 year, 2 year, or 3 year. And then after finishing that assignment or task, he comes back to his original company. So that is what is secondment is. And often you will find, secondment is mixed up with deputation. Some people refer secondment as deputation. In general, deputation may be for a short period. But the logic is same, that we are sending one of our employee to another company for doing some task, and then he comes back and joins the original company. That is what the secondment is. So the definition or the meaning is also available on Indeed.com, I think, which is a popular website when it comes to employment. So as per Indeed.com, one article available on the Indeed.com, a secondment is an arrangement where a company temporarily assigns an employee to a new position. The new position may be within the organization or with a separate business, such as client or supplier. Even if the position is at separate business, the original company usually retains the employee and pays their salary. Employees known as secondees work on a project during their secondment and return to their original position once they complete their responsibilities. While many secondments occur domestically, a company can transfer the secondee to an international assignment. Certainly, we have seen in the earlier slide and in this slide, it means, some short-term displacement kind of a thing from one organization to another, or maybe from one department to another department. And when this displacement is pretty wide, when you, let's say, travel from one company to another company, or from one country to another country, generally tax issues are much larger. So if the secondment is within the same organization, from one department to another department, probably there would not going to be much of our tax issues. But tax issues would going to be there if, let's say, there are two different taxpayers are involved. So from a one company to another company, or from one organization to another organization, and tax issues will grow more, if it's not only about the taxpayer, rather it's also about two different countries. So let's say, some expats are coming from US or Australia to India on secondment. Possibly, the tax issues would be much larger in comparison to, let's say, the employees are shifted from one Australian company to another Australian group company. So what is the debate on secondment? So, one is whether we should regard secondment as contract of service, or we should regard secondment as contract for service. So when it is regarded as, or when the secondment is classified as contract of service, secondee would be treated as the employee of the host company. Means, it would be treated as employee of the company to which he's moving. Whereas if it is treated as contract for service, then in such a case, secondee would be treated as the employee of the origin company or the former company, former employer company. So what happens, and this is the right point wherein we can discuss the possible issues. So let's take an example. Let's say one foreign company deputes or second, some employees to the Indian company or the Indian group company, and if the secondment contract fits in the category of contract of service, then the employee or employees who are seconded to India would be treated as employees of the Indian company. And if they are treated as the employees of the Indian company, the tax issues would going to be very, very minimal. And the only tax issue would be that those employees, the taxes, the salary which they are earning from India would be taxable in India or their host country. So it may be vice versa also. If we are shifting employees from India to, let's say, Singapore or Australia, and if it is contract of service, then the secondees would be treated as the employees of host company, which is in Australia, and they need to pay the tax, the employment tax or the salary tax in that host country. But let's say if instead of the courts classifying secondment agreement as contract of service, instead they classified the same as contract for service, then employee, as I told earlier, would be treated as the employee, or the secondee would be treated as the employee of the formal company or the original company, and then we would going to have larger tax issues. The first tax issue would going to be certainly because the employment is exercised in India. So until unless there is a short stay exemption, the salary would become taxable in India of that secondee, which was there in the earlier case also, that is contract of service. Second, now it would be regarded as service by the formal company to the Indian company or to the host company, and being it is regarded as service, it may get classified as fee for technical services depending upon the nature of service. And if it gets classified as fee for technical services, there would be tax on the service charge which is coming from the foreign company or the formal employer company. Whether it is on cost to cost or it is with markup, when it comes to FTS, generally it does not matter. Though there are few court rulings which says if there is a reimbursement, it would not attract taxes in India. But we are not discussing that, but just for the sake of moment, it will have a tax implication if the services are classified or secondment agreement is classified as contract for service. The third implication could be because of the presence of that employee in India, it may trigger the permanent establishment issue, maybe the fixed place permanent establishment, or maybe the service permanent establishment. So these three things may happen within the income tax domain. And also when it comes to GST, if it is contract of service, that is, if it is regarded simply employer-employee relationship, then GST will not have any implication. But if it is not contract of service, rather it is contract for service, then under GST law also, it would be treated as supply of manpower service, and one needs to pay tax in India on reverse charge basis. This was, if the transactions are cross-border, but it may happen that transactions are happening within the same tax jurisdiction. Let's say maybe within the jurisdiction of India. In such a case, certainly international tax issues would not arise, which we discussed. For example, permanent establishment, for example, fee for technical services. But yes, GST issue may do arise, when the secondment agreement is treated as contract for service instead of contract of service within the same tax jurisdiction. Because then, if let's say I have deputed or I have seconded one employee from company A to company B in the same tax territory, let's say India, but they are the common group companies, or even if they are not the common group companies, then also it would be regarded as service from company A to company B. And if it is regarded as service from company A to company B, then it will certainly have GST implications on the amount charged. So these are, possibly the tax issues which may come up, depending upon the classification of secondment agreement, that if it is classified as contract of service, then it's plain vanilla, only the employee will get taxed and he needs to pay the tax in the host country. But whereas if it is classified so that it can be classified as contract of service, but the litigation starts when court considers them as contract for service instead of contract of service. So let's move ahead and try to connect the dot, how court interprets or what is the differentiating line between contract of service and contract for service, which we all need to keep in mind while drafting our secondment agreements and arrangements. So a typical secondment model, based on my experience, which I've seen, is employee seconded to the host company would remain on the payroll of the original employer company. So employee seconded to the host company, but the payroll remains with the original employer company, and that original employer company may be in the same tax territory or maybe in some another country. Seconded employee would work under the control and supervision of the host company. The risk and reward of his actions belongs to the host company. There may be a situation wherein, let's say, the 100% of the salary is paid by the original employer or the former employer, or some part of the salary is paid by the former employer, and some part of the salary is paid by the host company or the host employer. But for sure, in almost all the cases, whatever the portion salary is paid by the former employer, that is cross-charged to the host company on cost-to-cost basis. Any query till now, or any point which any of you wishes to discuss? Okay, so let me move. So the core, the core issue when it comes to secondment agreement is to understand, what constitutes employer-employee relationship. And if the secondment agreement or arrangement qualifies the employer-employee relationships or fit in within the framework of employer-employee relationship, then certainly it becomes the contract of service. Otherwise, we know that it becomes contract for service. So we have OECD Model Commentary 2017, the commentary on para Article 15 on Article 15, gives some instances, some guidance, on the employer-employee relationship. Let's try to understand them. So para 8.13, the nature of services rendered by the individual will be an important factor, since it is logical to assume that an employee provides services which are an integral part of the business activities carried on by his employer. So somewhere, the OECD is saying the secondee should get fit in within the business model of the host company. It will therefore be important to determine whether the service rendered by the individual constitute an integral part of the business of the enterprise to which these services are provided. For that purpose, key consideration will be which enterprise bears the responsibility or risk for the result produced by the individual's work. So in order to decide, whether employee or the secondee is an integral part of the host company, one needs to check in, and it's not the sole consideration. One of the point, which we can check in is that who bears the responsibility or risk for the result produced by that individual work. So if risk and reward pertains to host company, then at least you have one check mark in your analysis. But there are a lot of I will say a point which one needs to check, and let's see what courts have to say on this. But before we go to what Indian courts have to say on this, we'll stick to what OECD is saying. Para 8.14, where a comparison of the nature of services rendered by the individual with the business activities carried on by his formal employer and by the enterprise to which the services are provided, points to an employment relationship that is different from the formal contractual relationship. So basically, this para 8.14 is most close to secondment relationships. So we have a formal employer, who is someone else, and then we have services are provided to some another employer. So para 8.14 typically refers to cases, which we can call secondment. So what are the relevant factors according to para 8.14, or maybe indicative factors as per para 8.14, which highlights that there exists employer-employee relationship. So who has the authority to instruct the individual regarding the manner in which work has to be performed? Who controls and has responsibility for the place at which the work is performed? The remuneration of the individual is directly charged by the formal employer to the enterprise to which the services are provided. So there are more points. So whether the host company is able to give the instruction to the individual or not, to the secondee or not, if answer is yes, so we can say, okay, we are more closer to employer-employee relationship. The next bullet given by OECD is who controls and has responsibility that this employee should work at this place. If the decision is of the host company, one can say, okay, there is one more check mark, so we are now moving more closer to employer-employee relationship. But are they concluding factors? The answer would certainly be no. So these are all indicative factors, and based on the totality, one needs to take a call that there exists employer-employee relationship, and we can call the secondment arrangement as a contract of service. Who is deciding the remuneration? Sorry, the third bullet is the remuneration of the individual is directly charged. So, if the formal company is paying the salary, so they are charging on a cost to cost basis, or they are charging along with the markup, or what is the basis for charging? Who puts the tools and material necessary for the work at the individual disposal? So let's say who is giving them the laptops, who is giving them some machines. So ideally, it should be employer's responsibility to give tools or machines, to employees to work. So if we are saying host company is the employee, so all those assets, all those tools and material should come from the host company. Who determines the number and qualifications of the individual performing the work? So generally what happens typically, so when I qualified way back in 2004, and when I was looking for a job, the call was taken by the employers, okay, that we need a chartered accountant, or we need a chartered accountant with X degree of experience, in terms of number of years and in terms of the subject. And today, when I go and hire, the call is taken by me. Okay, we need ex-employee or a chartered accountant with 2 to 4 years of qualification, or with this much of an experience in tax or in transpricing or in audit. So it is always the call of the employer, that I want 5 employees or I want 50 employees. I want this qualification within them, this exposure within them. So who is taking the call in the secondment agreement, whether it is the host company who is taking the call, or whether it's the formal company? So if everything is driven by the headquarter, then there could be a problem. But if the call is taken by, in substance, the host company, one can say, yes, we are moving more closer to proving that there exists an employer-employee relationship. Who has the right to select individual who will perform the work and to terminate the contractual arrangements entered into with that individual for that purpose? So when I've decided, that these are the numbers which I want, and this is the qualification, then out of the people coming to me for the interview, it is my call. It is the call of the employer to hire or not to hire. It cannot be the call of the HR company or someone else on this earth. It would going to be the call of the employer. Similarly, in the secondment agreement, very important point to find out whether the host company is exercising this right or not. The employee, the individual which got seconded to the host company, who selected that individual, and whether the host company has got right to terminate the contractual arrangement or not. Or it is like, after 2 years, definitely the employee, the seconded person, will move on to the formal company. So where is my right? Where is the right of the employer? And generally, when you put someone on a job, it is not for a 1 year or 2 year. Generally contractual jobs, which may not be regarded as job, which may be regarded as service, comes with a term. Otherwise, you will find when you are hiring, employee, you generally hire for a long period and not for a short period. Who has the right to impose disciplinary sanctions related to work of that individual? If that individual does something wrong, whether the host company can penalize that individual or not, or the right is with the formal company outside India to penalize that individual. If the right to penalize, to take action against that individual is with the host company, then yes, we are again more closer to employer-employee relationship. As I said earlier, we need to evaluate a lot of factors, and not only one factor can decide whether there is an employer-employee relationship or not. Then who determines the holiday and work schedule of that individual? These are all indicative points on which we need to work to find out, whether there exists employer-employee relationship or not. It is important to note, however, that the question of whether the remuneration of the individual is directly charged by the formal employer to the enterprise to which the services provided is only one of the subsidiary factors. So these are all indicative points, which we need to work upon. Again, a very famous judgment referred in various courts is from the House of Lords. In the matter of short VJ and W Anderson Limited, wherein the court gives the four indica or four principles, based on which you can one can classify whether it is contract of service or contract for service. And those indicas are the master's power of selection of a servant, the master's responsibility of payment of wages or other remuneration, the master's right of suspension or dismissal, and the master's right to control the method of doing the work. So, one can see that judgment is pretty old, and in the modern world, it is not about master or servant. It's about employer and employee. But still, we can take some learning from this judgment. And those learning is, whether I'm able to select my employee or not, who is paying the remuneration to that employee, who is responsible for paying remuneration to that employee, whether I can suspend or dismiss that employee or not, and whether I can control the way he is working. So if I see these principles or points, and if we see what is written in the OECD, one gets a feel that the role of the formal company or the role of the original company is very limited and should be very limited, and that too only managing the payroll. The rest, all the decisions should be with the host company. So if you are working on some secondment agreements, just try thinking whether those secondment agreements satisfy these conditions or these principles or not, and do they need any modification. So let's see, what courts have to say. These are some judgments which are against the taxpayer, and certainly, there is an important judgment by the Apex Court in the matter of Northern Operating Systems Private Limited in the case relating to service tax and non-international tax. But yes, we can see the principle, and I will try to correlate it with the again the judgment of the Apex Court in the matter of international tax, and you will find that both are more or less on the same page, and also what we have seen in the OECD. So whether irrespective of the law, whether it's the GST or a service tax law, or whether it's the international tax law, the matter, the principle to evaluate whether there exists an employer-employee relationship is same. So these are the finding of the Apex Court. As discussed previously, there is not one single determinative factor. There is not, as I said earlier, there is not one single determinative factor. There are a bundle of rights which are there with the employer, and whether those rights are with employer or not is important to evaluate. With the court give primacy to while deciding whether an arrangement is a contract of service or contract for service. The general drift of cases which have been decided are in the context of facts, where the employer usually argues that the person claiming to be the employee is an intermediary. This court has consistently applied one test, substance over form, requiring a close look at the terms of the contract and the agreements. So each agreement could be different. Sometimes we may do planning, that, okay, I want to depute my person from, X group company to Y group company. And accordingly, I have arranged my papers, but the court is saying we need to see substance over form and not what exactly is written in the documents. So the vital fact, in Northern Operating System, which court observed was, the vital fact which is to be considered in this case is that the nature of overseas group companies business appears to be secure contract, which can be performed by its highly trained and skilled personnel. So they were, getting the contracts which can be performed by highly trained and skilled person. This business is providing certain specialized services like back office, IT, bank, related services, inventory, etc. And then they used to outsource it. So based on the briefly, if I can tell you, let's say the foreign company was entering into contract or winning the contract, which were more in the nature of which require the expertise, and some portion of those contracts, or maybe the entire portion of those contracts, were outsourced to India. And in order to execute those contract or some part of those contract, few people were deputed to India. So that's now the deputation or the secondment was happening to India. Now, whether it is a contract for service or contract of service was an argument. So the court said, basically court is evaluating, when the employees are coming to perform specific task in India, and the arrangement is shown as secondment agreement or contract of service, whether it actually contract of service or not. So this business is providing certain specialized services, taking advantage of globalized economy and having regard to locational advantages. The overseas group companies enter into agreements with its affiliates or local companies such as the SSE. The role of the SSE is to optimize the economic edge to perform the specific task given it by the overseas company. As part of this agreement, secondment agreement contract is entered into, whereby the overseas company employee or employees possessing the specific required skills are deployed for the duration the task is estimated to be completed in. So just think, so it is not the secondment is not done to carry out the work which Indian company is required. Secondment is being done to carry out the work which has been subcontracted to the Indian company. So it is not the work of the Indian company which secondee would be doing. Rather, it is the work of the foreign company which secondee would be doing in India. So this court is not concerned with the unraveling the nature of relationship between the overseas company and the SSC. However, what it has to decide is whether the secondment for the purpose of completion of SSC job amounts to manpower supply. Furthermore, the reality is that secondment is part of the global policy of the overseas employer loaning their services on temporary basis. On the cessation of the secondment period, they have to be repatriated in accordance with the global repatriation policy of the overseas entity. Now, if you see these two para, apparently, the secondment which is happening is part of the larger contract, and being part of the larger contract, most of the things are decided by the formal company or the foreign company, and the role of India company seems to be limited about the management of the employee. But as far as what should be the salary, what should be the repatriation policy, when can I fire, all those rights were not with India. The guys were coming to India for a specific purpose. They were completing that purpose and they were going back to their foreign company. So it was, the court concluded that this secondment agreement is not an agreement for employment, rather it is a contract for service, and thus it should be seen as that services are rendered by the foreign company to the Indian company, and accordingly the court ruled in the favor of levy of GST on this transaction, levy of service tax on this transaction. We have another judgment in the international tax, Morgan Stanley. We have a Supreme Court judgment, but before it went to Supreme Court, it went to Authority for Advanced Ruling, and there are some important findings of AR with regard to the contract. Let's see what it says. It says the staff deputed to the Indian company would be on the payroll of the foreign company, and the remuneration paid by it will be reimbursed by the Indian company. Performance appraisal, promotion, and discipline, etc., would be carried out in consultation with the applicant. Applicant in this case is the foreign company. So employer, we are saying the employer is an Indian company, and employer cannot carry out independent appraisal. It cannot carry out independent promotion and other issues. Rather, it needs to discuss with the foreign company. Does it happen in an independent scenario? Does employer goes to some third party to discuss or to take the permission? No, employer has got the absolute right to decide, what should be the salary, whether I should promote or not, what should be the discipline mechanism that should be followed. But in this case, it was in line, or it was after the consultation with the foreign company. It is understood that employees of the applicant are to be sent to Indian company, whether for stewardship activity or for deputation basis for more than 90 days. The council has emphasized that the staff would be working for the applicant only. We are unable to see it. It may be that the benefit of service of staff would inure to the applicant, but it would not be the same as working for the applicant. So the court further went on to give the example that, let's say, in a manufacturing entity, if labor is working and producing articles, the benefit is going to the public. So does it become the employee of the public? No, it is not the case. The same thing the AR said. So if employee is coming to India, working for Indian company, does not mean that it is it becomes the employee of the Indian company. So we need to see whether the rights are properly exercised or not. And when the matter went to the Supreme Court, what Supreme Court said? In para 15, as regard the question of deputation, an employee of MSCO, which is a foreign company, when deputed to Indian company, does not become an employee of the Indian company. A deputationist has a lien on his employment with the foreign company. As long as lien remains with the foreign company, the said company retains control over the deputationist term and employment. So when the lien is with the foreign company, I cannot fire that employee. If a host company is not able to fire the deputationist, then it would be wrong to say that the host company becomes the employer. So if we read OECD and if we read what happened in the Supreme Court judgment in the case of Northern Operating Systems, and the Supreme Court judgment in the case of Morgan Stanley, and the 4 indicas given by the House of Lords, all these points suggest that the payroll may remain with the formal company, but the various rights of the employer should be exercised by the host company, including the firing of the employee. If I can fire him, if I can hire and fire him, possibly one can say that, yes, there exists employee relationship along with the other indicators. The another finding of the Apex Code in case of the Morgan Stanley was that on completion of his tenure, he is repatriated to his parent job. So the point is, it is like, plug in, plug out. I'm sending an employee for, let's say, 1 year, he will complete the task, he will come back. So this does not happen in the normal employment model. So based on this, the courts said it would be considered as contract for service. Now, where in the contract, the court has considered secondment as contract of service, is one of the, we can see the judgment in the matter of away business services by the Karnataka High Court. The Karnataka High Court observed that it is also pertinent to note that secondment agreement constitutes an independent contract of service in respect of employment with the SSC. From the perusal of the key features of the agreement, which have been reproduced by the Commissioner Appeals, it is evident that the seconded employee have to work at such place as the SSC may instruct, and the employees have to function under the control, direction, and supervision of the SSC, and in accordance with the policies, rules, and guidelines applicable to the employees of the SSC. The employees in their capacity as employees of the SSC had to control and supervise the activity of MSource India Private Limited. Therefore, the SSC, for all practical purposes, has to be treated as employer of the seconded employees. So based on these judgments, one can say that if majority of the rights are with the host company or Indian company, one can conclude that the Indian company is employer of the foreign company. This was, I was having for all of you for this topic. And if you have any questions on or wish to discuss any point on secondment, we can discuss. We see whether we have something on a chat box. Can it raise a P issue as well in future? Certainly, Rohit, let's say if the employees, if the deputed employee in India is treated as the employee of a foreign company, then depending upon what is there in the treaty and depending upon the role of the secondee, certainly one may conclude that there is a P or not. So it depends upon the facts of the case. But yes, it can give rise to permanent establishment. Sandeep is asking, in domestic cases where manpower is supplied by agency to a company, it is the company which exercise controls the employee. Salary is paid by the agency to employee who then recover cost. The fee is called manpower service tax forward. Sandeep, I think we have discussed in detail, that if you are having the control, if salary is decided by you, if you can fire the employee, then the role of the manpower company is limited only to managing the payroll. So manpower company is only providing the payroll administration services. And if they are charging some fees for those payroll administration services, then certainly GST would be there on that service. But as far as salary part is concerned, in my view, it can be treated as reimbursement. Any other question?
Hello.
Yeah, Deepak.
Yeah, good afternoon, sir.
Good afternoon, Ji.
I have a query on secondment. One of the company is having seconded employee in India from overseas parent company, right? Salary is paid by parent company and it is reimbursed by Indian company on cost to cost basis. And some extra salary is also paid in India. So on total salary, which is reimbursed to parent company as well as which is paid in India, on total salary, TDS is deducted in India as per salary rules under section 192.
Okay.
So my query is if
Deepak, your voice is breaking. Hello. Deepak, you are not audible. What I understand that, in your case, there is a secondment of
salary, total salary result in double taxation.
No, Deepak, I'm not clear on the question. What I understood is that there is a second in India. Some portion of the salary is paid outside India. Some of the salary is paid in India. And the TDS.
Hello.
Hello, Deepak, am I audible? Deepak, you are not audible. So, okay, let me take this example. In the case shared by one of our participants, CA Deepak Kakkad, the secondee employees working in India, and some portion of the salary is paid outside India, and some of the salary is paid in India. And on the entire salary, that is the salary paid in the foreign country and salary paid in the Indian company, taxes are paid in India. So whether this position is right or wrong, in my view, as far as salary position is concerned, it is right. Because the employment is exercised in India, the salary would become taxable in India. But whether the secondment agreement would be treated as contract for service or contract of service, I think we don't have the proper facts to comment upon that. But as far as salary tax is concerned, I think the position is clear. Because the employment is exercised in India, so it would become taxable in India. Any other question? As far as PPT is concerned, I have got your mail ID, so I will share PPT with you, with all of you through my email. Deepak, hope you got the answer.
Sir, my connection was out. I think I didn't hear it.
So basically what I said, if the employment is exercised in India, the entire
Yes.
salary would become taxable in India.
Yeah. So what about FTS if all the conditions of contract for service are also established?
If let's say it is treated as contract for service and not contract of service, then
Yeah.
it would be treated also as the income of the foreign company, correct? And then we
Yeah.
need to see whether it is triggering permanent establishment or not. Because in case of permanent establishment, you do not pay tax on. We'll request everyone to please put them or put yourself on a mute mode. So if let's say there is a permanent establishment case, because generally it will cross the number of days threshold, and also being it may be treated as fixed place PE. So the taxability would happen on a net basis, and if it would happen on a net basis, whether the permanent establishment has been remunerated on an arm's length basis or not, that is also one point we need to see. But as far as it is concerned that okay, I am paying let's say $1,000 as salary and $1,000 would be the FTS, and I am collecting TDS on $1,000. It may have a repercussion on the working capital, but depending upon the status of the non-resident in India, one can file a refund and one can file a return and claim the refund.
Okay.
Okay. Thank you, Deepak. Any other participant has any question? Feel free to discuss, or if you want to write in a chat box. I think we are done with session. Thanks to all of you for joining. The session is available on my YouTube channel. I would be sharing the link of my YouTube channel and also the presentation to all of you, with all of you on your email ID given to us. Thank you and see you again.